Hello, everyone, and welcome to our webinar today where we'll be discussing strategies for managing a global patent portfolio. Thanks, everyone, for attending. And before I begin, we'd like to at least introduce ourselves. This is Mike McCallum. I'm at Brooks Kushman. I've been here for about a decade, and primarily my practice focuses on both U.S., but in particular, some global patent portfolio management as well.
Good afternoon. My name is Mark Jurtanovic. I'm a shareholder at Brooks Kushman. I've been with Brooks Kushman for approximately a decade as well, a little bit less than a decade. And my practice is focusing on patent litigation and patent prosecution, where I manage several domestic and global patent portfolios for companies located both in the U.S. and outside of the U.S. Thanks for attending.
My name is Anton Pikovic. I'm the director for intellectual property and the intellectual property department in the Americas region for Schaeffler. And Schaeffler is a global manufacturer of various components and assemblies in the automotive, aerospace, and industrial technology areas. Schaeffler is a German-based company that files, I think it's the second largest by quantity, at least, filer of applications, of patent applications in Germany, and also one of the leading filers of patents globally. So in the US, that translates to something like between 200 and 400 foreign origin, so non-US origin patent applications. And that's true in China and Japan as well. I think the total last year was something around 2,300 or 2,400 patent applications filed in Germany. So we, in the regional department, manage those foreign origin filings and bringing them, nationalizing them, or bringing them into the US.
All right, thanks, Anton. So today, the main focus of our topic today is global patent management. And some of the main topics today is really just from an in-house perspective, what are your overall international IP goals, if you've even thought about that, and kind of looking into the future as well? Where do you see your company being in 5-10 years as far as IP management worldwide? That would include, more particularly the PCT filings versus direct to national filings. That plays certainly a role in cost management, dealing with workload, et cetera. And speaking of that, managing both domestic and foreign outside counsel is a large part of that as well. And I'm sure Anton can speak heavily on that. And then also, finally, some tips and practice points to when applications are filed elsewhere and they're entering the United States. What are some things you can do to get ready to efficiently enter U.S. examination to assure, again, efficiency in prosecution here in the United States? So having said that, just to get, juices flowing, so to speak, we've got just a quick chart here on, this is the latest data from 2016 of patent applications by country at the PCT office. And clearly we see China off the charts, US next, and it kind of trickles down from there. The next slide right here, this is PCT applications growth since 2016. The United States has stayed pretty stagnant, so US originating cases going into PCT has held constant, but still number one filing in PCT. But the foreign applications going into PCT and then divvied out elsewhere from there starts with China and Japan and Germany. So I guess is not too much of a surprise, but this is where you'll see a lot of applications coming from going into PCT first or PCT eventually. China with the extreme largest growth out of anybody else, more than double. Well, we've got China with 13% growth since 2016. Clearly, it's no surprise that China's ramped up its filings, and that includes both in China, also direct to US, but in particular, as shown here, just PCT applications as well.
So I can take it from here, at least on this slide. I think that step one, and when we were discussing this presentation, we launched into how to prepare applications, but then to back it up a step, you really have to understand your company's and your product's direction before you can even decide where you're going to file and how you're going to file. And a lot of that is the difficulty of being in an in-house IP department is you can't just focus, again, this is my opinion, as anything, there's 1,000 opinions on this, but I don't think as an in-house IP department, you can just focus on the mechanics of filing and getting good claims. It's not just that. It's also understanding the corporate strategy, your corporate goals, where the markets are heading. So step one would be, of course, an easy one, where your product's being sold. It sounds easy, but in a company as large as Schaeffler with 85,000 employees globally and multiple development centers, it's not necessarily the easiest calculation. And that can vary from company to company. If it's a smaller startup, of course, you likely know your market and where you're going. With larger companies, it's more difficult getting that information and communicating it properly. So understanding where your products are sold is a good starting point. And then the second and maybe more advanced point is understanding where you want to enforce this. And that requires a larger understanding of the market and your competition, your competitors, which is a next level, a next step of evaluation and strategy that, again, most IP departments do not have. What we do is we interact with the product lines or the business units related to each individual product or component, because they, in theory, should know this information. So we have a lot of interaction with those products, with those product lines and those business units to understand what their strategy is, where it's being sold, and they are very involved in the patent process. This is something that the IP department, again, has that interaction with the product line, understanding where you can litigate and where you can license and where it's feasible to do that. So as a broad example, there's a lot of, for example, automotive manufacturing in Mexico. A lot of that, not all of it, but a large percentage of that comes to the US. Enforcing a patent in Mexico is much more difficult because there isn't really a doctrine of equivalence with those, which those of you who are familiar with US law would understand. It's a very literal examination of the claims. So it's a lot more difficult to enforce typically unless you have an exact product copying situation. So in that situation, again, knowing those two jurisdictions somewhat well or relatively well, the strategy would be file in the US if you know most products are going to the US, just as an example. And then again, all of you that are in IP departments know that some of what we do, or at least a good percentage of what we do, is forecasting. So kind of crystal ball, look into the future, because patents last for 20 years and you have to know where your product's going, what you want to file, and whether it's going to be enforceable in the future. And similar situation with emerging markets. If you ignore markets just because something's down, like in Brazil, for example, at the moment, 5 years ago, Brazil was up and coming. Then they had a financial hit a little bit. In 5 years, they'll be back up again. And in those intervening 10 years from when they were high to now, and when they're back up on the wagon, many people would have avoided filing in Brazil, which might be a missed opportunity. So taking all these considerations into mind as an in-house IP department, you can never do it perfectly, but it's something that you have to consider at each step of the game. And again, just to reiterate that, to really have an effective filing strategy, you have to go at a very broad level initially. And having people understand the technologies and being focused on their technologies is very important. So understanding your company's goals. If you're shifting from component supply or mechanical supply to electric vehicles or autonomous vehicles, your filing strategy should reflect that. So rather than filing a lot of component patent applications, your filing strategy has to shift. And if you're targeting markets, emerging markets like China, Russia, for example, again, your filing strategy has to shift. Otherwise, you're not going to be in line with your company's goals. Again, your company's profile, Schaeffler, for example, is shifting a lot from components to assemblies, understanding how that's going to happen and how that interacts with your department. And it goes without saying that all this costs money. You can't file everything everywhere. So understanding what the resources are that you can use and what resources you have internationally that you can rely on and understand what the market's doing is a key factor. If you don't know any of this information, you're basically walking into it blind and you're spending a lot of money that you don't need to. We can all address this to some extent, but when to file applications at the PCT. And this is, again, there's as many opinions about this as there are probably in-house IP departments. And it really comes down to those three questions that are up on the screen, I think. I think those are the main ones that come up every time. It's the uncertainty with where you want to protect those products. So again, if you know that product is going into, in our case, Germany, US, and China for sure, but you're not sure if it's going to go into the wider European market, or if it go maybe in Southeast Asia or Japan or South America, then maybe you want to do a PCT to understand where that market expansion and where that product is going to take off. The other side of it is that, of course, if you know that there's where you want to file this, and in our case, the general rule of thumb is if it's 3+ countries, or inclusive 3 or 2+ countries, that we do a PCT because it makes more sense. It's a simpler way to do it rather than going to each country individually. If it's just one country, it makes more sense just do direct filing, for example. And again, the last one, delay in prosecution. So you want to see where the market's going, where the product's going, and maybe you don't want to pursue it anymore. Maybe there isn't enough market interest, or maybe that product doesn't work as well as you hoped it would. So in some cases, it's wise to have that extra 18 months to consider where it's going to go. I don't know if you guys have anything to add to that.
Yeah, one point I wanted to iterate is my understanding, at least from a cost perspective, and I would imagine a lot of the decision making, whether to go to PCT to direct or EPO to direct, is how much is it going to save me money by doing one or the other. And it sounds like from the research I've done, 3 to 4 countries being filed, whether it's, and that applies for both PCT to direct or EPO versus direct, is kind of a threshold. So takeaway is if you're at 3 or 4, you might have some decisions to make, but if you're above that, it's going to be cheaper to file directly to the EPO or through the PCT. Underneath that, you're probably cheaper off with a direct filing at the national entry stage.
So I'll start with this again, I guess. And again, it reiterates the point that I mentioned earlier. If you know what your major markets are, and that's also technology dependent, I think the next slide is related to where the main markets are for certain technologies or where the main market interest is. Of course, larger markets like the US, European Union, Germany in particular, and some of the Asian markets like China, Japan, and India, it's easy to decide some of these countries and some of these markets. The problem lies in missing good opportunities, like, for example, Brazil, Russia, Korea, South Korea. If you saw the earlier slide, the domestic filings of patent applications in China is gigantic. If I recall, it's 1.2 million or something. If you don't file in China, you're competing with 1.2 million other applications that might cover something similar to your product, where you might have a detriment. And if nothing else, at least it gives you the opportunity to sell your product free of encumbrances. I didn't mention this earlier, but part of the strategy, of course, is enforcement, and part of it is protecting your own product. So if you don't have a patent out there and you're selling it to some of these markets, like I would say China in particular, and I think Japan has a reputation of filing a lot of domestic applications as well, you're at a disadvantage because someone else is likely going to file something similar that you might have to combat in the future. So it might just be as good of a strategy to file defensively, meaning that you're filing to cover your product and make sure that you're free to sell the product. Yeah, again, where the competitors' manufacturing facilities are located. Again, it's knowing your market and knowing where your competitors are. It's more difficult than you'd think to know some of these pieces of information, especially with the changing global economy. Things are shifting so quickly. You can't sit on your laurels and understand what worked 10 years ago and keep on using that strategy. It just doesn't work that way anymore. A prime example for me, I was just speaking with a Chinese colleague, and even the Chinese market manufacturing to some extent is going to other countries in Southeast Asia for even cheaper labor, like Vietnam, like the Philippines, where traditionally we haven't filed anything, but maybe in future we should. I don't know what the enforcement strategies are, what the likelihood of enforcing there is, but if that's where manufacturing is shifting, it's a consideration for the future. Yeah, and again, just to reiterate the last point, and if you guys want to add to it, go ahead. Sure. I think knowing the Schaeffler is mainly, again, as I mentioned, automotive, industrial, and aerospace, mechanical fields or electromechanical fields. So we know our main markets, but as you get into new markets, again, autonomous vehicles, e-mobility, what we call e-mobility, so electric motors and hybrid drives and so on, that might change. And I think going into, in particular as in-house, for someone coming from outside counsel, going to in-house, I think one of the things that came out in our discussions with Mark and Mike was they don't have to consider these things, right? They know the filing strategies, they know good claiming, they know the considerations in those jurisdictions, but knowing where those markets are and knowing what the detriments are and what you're facing and the competitor you're facing in each one of those technology areas is key as in-house counsel. So it's almost step one. If you're coming from outside and going in-house, is take some time to understand the business side of it, because just focusing on the legal part of it, you're going to not have an effective strategy.
And even on with our discussion, we talked about even knowing like the nanotechnologies that are focused on each country. So, being that we're in Motor City, we have big cars in the U.S. We have F-150s. You used to see the H2 Hummers back in the day, not anymore. But those cars I know is popular in Europe. So does something like the technology that applies to like heavy industrial or a huge, large SUV that may not be sold overseas in Europe or China, does that affect filing strategy as well?
Yeah, absolutely. So, for example, the oil sands, it's a very limited market, but it's very specialized equipment. So you might file only in Canada and the US, or fracking. It's outlawed in most countries other than the US where it's available. If you come up with something useful for fracking technology, you might just want to protect it in the US because that's really one of the only countries in the world that's doing it. So yeah, understanding where market trends are is, again, you're going to spend a lot of money and you're going to waste a lot of time filing. If I just said, oh, this is what a great idea is, downhole drilling. We have a mud lubricated bearing. It's only used in the US. If I didn't know that, we could file it in China, Germany, spend tens of thousands of dollars and wasted effort for something that will never be enforced, never be used in those markets. So yeah, understanding what the market trends are and what the value of those products are before you file is step one. Again, I keep on reiterating that point, but it really is step one. And maybe getting that key interaction with the business people before you file. And then the other considerations I mentioned, whether it's enforceable or not. So again, you don't want to maybe file in, I don't know, Colombia or something if you're not going to enforce it in Colombia. So yeah, I think this is one of the last slides and I can pass it on to the other guys. What we do at Schaeffler, at least, is we reevaluate. So we have a patent committee, and the patent committee includes a patent and assigned technology expert patent attorney related that's ultimately makes the decisions on filings. Within that committee are also the product line specialists. So they have to have a cross-pollination of knowledge, meaning the patent attorney has to have some business knowledge and the business people have to have at least minimal patent knowledge. At each step of the process, a review of the patent application and the initial invention disclosure is done. And I think that's good practice across the board. So at the initial decision to file a priority application, what's supposed to happen, and this is inconsistent depending on the patent attorney and maybe the patent committee, but what's supposed to happen is that they identify the scope of the invention. So how broad or how narrow of an invention do they expect this to be, and what do they want to get internationally, and where do they want to file internationally? So that initial decision is a very important step, but at every step it's reevaluated. Again, at the 12-month date, whether a PCT should be filed, going back to our considerations about how many countries and so on, what the market's doing. At the 30-month date, whether you want to nationalize and where you want to nationalize and whether you even want to nationalize anymore. I mean, you have an opportunity at each one of these stages, although money has been spent, to also abandon applications and to not bother filing. So save some money or not pursue certain applications. Knowing the scope of the initial filing or the scope of the initial invention, you can go and look at the prosecution. So in this case, just anecdotally and what I've experienced, most prosecution starts and is completed first in the US because in many other countries you have to request examination. So typically an application in the US can inform how you prosecute the application in other countries, meaning you'll know the prior art that comes up, you'll have the search report already, and if you're paying attention and people and your international team, if you have an international team, is communicating well, you can inform how you modify the claims and what arguments you can make in other jurisdictions. And again, whether you want to pay grant fees and maintenance fees, all this information is documented and at each step it's evaluated anew just to make sure that the market hasn't gone away from this product or the market has focused more on this product. Can we do other things? Can we do continuations and so on? So at each step, that base knowledge is recorded and reevaluated to see whether it's still accurate.
All right, Anton's been doing a lot of talking, so we'll let him relax now and have some water.
I'm tired.
So we wanted to talk also about, so now you've decided on the flip side, we're going to be entering the U.S. market now from a foreign originating cases, and that may come in through foreign in-house counsel, even from foreign outside counsel as well. And we wanted to talk about some things to better prepare the application for U.S. Examination and efficiencies as well.
So we'll go with what we view as the old school way of preparing patent applications. And when we say old school, this is the way that we've seen the trend of foreign cases that enter into the U.S., the types of changes that are made to that originating case as it enters U.S. National stage. And we have the gramophone on there to emphasize we're all technology related here, given this is an IP patent session. So that we have our old school technology as well with the gramophone and record player. And the old school way is basically getting that application ready just enough so that you can get it through and the examiner will look at it and not crumple it up and throw it away. So what typically counsel does is amend the claims by removing the reference number, so all the reference numbers to the elements that are in the figures. Remove language that is kind of unique in the foreign countries' application process, such as characterized by. We see that with a lot of European cases. And multiple dependencies, which is also common in the foreign practice. And you might have, with respect to the claims, those are some of the amendments that we see. With respect to the specification, you might have some very slight amendments by adding the different headings of your patent application. So the detailed description, the title, the abstract, so forth, but nothing too substantive. And typically you get those done relatively quick, file it, and wait to see what the examiner says without doing much else substantive.
And then now this is 2018, so there's a lot more you can do now to just getting this application prepared. And this is what you should expect out of colleagues, outside counsel as well. And that is, it's all about getting more bang for the buck. When you're filing this application in the U.S., the overall goal is to get this thing ready for examination on its first examination, so that you're not just having wasteful rejections by the patent examiner. And we've a couple of slides later on that kind of show that in practice, what reducing inefficiencies in filing in the U.S. can really do to you financially. So instead of just doing all those really kind of high-level things very quickly to your case, the expectation, I think, to get your application ready to be filed should be more than that. It's not only doing what Mark was just talking about, but also, that's a perfect opportunity to obviously amend your claim scope in view of any search results that you have or any foreign examination you already have upon filing in the U.S. So you're not just churning out the claims and filing the case in in the U.S. almost as is. This is a great opportunity to amend the scope before the examiner gets a chance to attack it himself, and so that way you can get another bite at the apple. Also, a lot of claims that come in, a lot of claim sets that come in from foreign offices or foreign colleagues don't have the full 20 claims. They may have 10 or less because that kind of sets them up from a foreign prosecution standpoint. Well, here's your chance to get to 20. You paid for 20, so you might as well get them. And to get to 20, it's not just turning your multiple dependencies into 20 straight claims. Let's get an extra claim set or two if you can that covers alternate embodiments or maybe different breadths of scope as well. And also you can clean up the specification to better suit the U.S. practice, obviously without adding any new matter. But the way to do that is there are some certain words that are used in foreign applications. For example, means by or means of. If someone says, oh, well, the blender works by means of electricity. Okay, that certain word might trigger obvious actions here in the U.S. that are not intended. So it's a way to clean that up right off the bat so that you're not having these issues going forward in prosecution. And again, by doing all this, you're setting up the application for an actual examination on its first examination, instead of, I can't tell you how many times I see an office action come in, obviously that I didn't touch, but an office action that comes in and it has a broad rejection that just says, you've got all these 112 issues, you've got all these terms in the claims I don't like to see, that no one really here in the U.S. likes to see. And that's the extent of your first examination. So now you go off and you, after that first office action, now you go clean up those issues. And now all of a sudden for your first examination with prior art, it's a final office action. And we can go forward about talking about the cost and efficiencies of that, because now you don't have a chance to work with the examiner twice on cleaning up claim scope. You've got one shot, and by the way, to do that, you're going to be paying RCE fees, et cetera. So, yeah, so this was just, we talked about specification. One of the things, real quick is, this is one example. I said means of is one thing you might want to look out for. Using case law as a guide, these are other things as well. For example, a decade ago, the case law that has looked at this and follow on since then. If you're characterizing the invention is this, the invention is that over and over in the specification, that can certainly come back and limit your claim scope, not only during examination, but most likely during litigation after that. Using words like preferably, must, or other dispositive language, and et cetera. And again, the point with that is to stay up to date with case law, so that and an expectation from getting these cases set for the U.S. examination is that you are up to date with your case law, that all of these things, every time there's a lesson to be learned, it's because of a problem a roadblock or something that somebody had when they were preparing their case for U.S. Examination.
And we don't expect everyone to read the first claim, but this is just one example of a application that came in from Europe that we examined, and we saw that first claim. And when you pick up these applications that come in from overseas, you read them, you get a good sense of what the invention is, and then you look to the claims and you think, God, why do they claim all this stuff that doesn't matter? And you look at all the limitations that may not matter in U.S. practice, because in other countries they might have all these different requirements that you don't have in the U.S. to kind of set up the scope of the invention and all the other background. And you might want to avoid those in U.S. practice because, as a general rule, it might be tougher. There might be more outs for a non-infringement position with more words, as generally speaking. So this is a case where, rather than just amending the claims as the old school gramophone way, we did it the new school way, and we added some new claims. And you can see that on claim 10, it's a lot more focused on what the invention is than the surrounding parts. And in fact, this was a case where I think the first claim set had some rejections on, I can't remember if it was prior art or 112, but nonetheless, the new claim was allowable. So what that did is if you can, going back to Mike's statement, you have the substantive first rejection, and you know how to handle that rejection with respect to the originating claims because you did the extra effort and gave the examiner a chance to really understand the invention and find the art that applies. And in the end, it avoided a final rejection and got the claim allowed quicker than typical gramophone practice.
Mm-hmm.
Yeah, this is goes to what Mike and Mark were saying. But depending on the size of your IP department, and this is predicated on whether you have foreign colleagues. So from the U.S. perspective, meaning for a larger corporation like with Schaeffler, we have a German office or German IP department. We have a Chinese IP department, and we have Asia Pacific, and of course U.S. IP department or America's IP department. So when you have in-house departments around the world, alternatively, you have foreign associates that you interact with, especially that draft your applications in other countries as priority applications. Ideally, and I haven't come to a firm resolution on this even within Schaeffler, but to come to some sort of standard or some sort of understanding that you can prosecute some of these applications with greater ease in other countries. So a prime example for that for me is just getting more figures or getting more illustrations and more figures in the priority applications, so that's something that we can rely on in the US as disclosed as within the specification. The other is characterizing prior art or limiting characterization of prior art because that can be admitted prior art in the US. And in some countries, for example, in European practice, it's very common to describe the prior art in great detail and then explain how your invention deviates from that or overcomes some problem associated with that. If that can be avoided or downplayed, it can aid U.S. prosecution. And of course, taking into consideration your other markets, primary markets, for example, China or Japan, whatever they may be. If you can come to some understanding of this is suitable or good enough for European practice, and it's also beneficial in Chinese and U.S. practice, everyone can be happier, and it can be more enforceable if you can come to such a standard. And again, that ultimately depends on where your applications are going to be filed from the start. So maybe different templates can be established for different levels of application.
So we mentioned before that the AirPod way of doing the new school way of amending claims can have some cost savings for preparing the application. And as Mike said, and we'll reiterate, if you have a substantive first rejection, you're not facing substantive rejection at the final rejection stage, where you may be forced to file either an RCE or or just take it to an appeal. So with that, when you make those substantive changes up front before you receive an office action in the U.S., you increase your likelihood of reducing not only fees at the Patent and Trademark Office, but attorney's fees, because of course, I'm sure all the in-house counsel on the board understands that your outside counsel is not going to be writing these appeals and extra office actions for free unless you're really good at negotiations. So that being said, if you're reducing an appeal, you save approximately, if you're a large entity, $2,800 in U.S.P.T.O fees, and it's just with the government. Of course, you're going to have additional fees from your attorneys where they're going to have to file an appeal and likely have a reply as well. So those are some things to consider that you can avoid. And with an RCE, you'll save approximately $1,300 in U.S.P.T.O fees if you're a large entity, and obviously the fees that come with your attorneys making amendments and responses to that final rejection. And of course, there's a bonus. You're really not only increasing quality because you're, with the cases that come from abroad to the U.S., those cases are square pegs, and you're really trying to fit them into a round hole. When you make these amendments, you're kind of sanding off those corners so that they fit for U.S. practice. So obviously quality is a concern and cost savings is a concern, but you have potentially faster time to issuance, which can be a benefit for your company. And you have reduced prosecution history estoppel. Because you have less correspondence with the patent office, you may limit the likelihood of making detrimental statements that can later be used against you in litigation or an IPR and so forth.
And I'd verify that from in-house counsel perspective, especially in the RCEs. A number of years ago, that came up a lot with our prosecution in the U.S. based on foreign origin work. It was really problematic. It came up very frequently, so we changed our procedure as a result.
So this is just a kind of high-level case study, a cost-saving study, I should say, that we did, and we have some assumptions to assume here. So this is for our 100 patent docket. So you're managing 100 patents in your docket, and appeal costs and fees. We took the fees that I mentioned, obviously from the U.S.P.T.O for a large entity, and we used AIPLA's averages for attorney's fees for an appeal and a reply, which came out to $3,200 on average. And then the other assumption is for RCE, it was $3,300 total between government fees and attorney's fees, and that was based on AIPLA averages as well, which is $2,000 for an average amendment and response. And rather than kind of guess how many extra office actions were attributed to an appeal versus an RC, we kind of split that. And so with this cost savings analysis, if you look at the table on the right, you have your percentage of office actions reduced. So this is the amount of, if you make amendments to your specification and your claims up front, rather than waiting for a first substantive rejection, what likelihood of reducing, what percentage or what likelihood of reducing a office action is that? And I think we have, a range of between 10% to 50%. And Anton can probably speak on what he sees in his practice, but just to give an example on the assumptions, if 10% of your 100 patent docket reduces an extra rejection, we attribute in these assumptions, 5 of those would be attributed to avoiding an appeal, and the other 5 is an RC with a substantive amendment and response. And you can see the cost savings on the right based on those assumptions. So if you just reduce the office action responses on 10% of your cases, you have almost a $50,000 savings. If you can reduce 50%, you get significant at around $232,000 in savings. And Anton, I don't know if you can speak with doing the new school approach. What percentage do you see? Is it higher than 50%? Is it lower?
Yeah, I don't know if I can verify the numbers necessarily. Not having looked at it, this is more a generic overview. But on the other side, I think this is a nice analysis as far as cost savings and the potential for cost savings, and it really depends on your portfolio what happens. But I see that there are cost savings available, but more importantly from my side, or maybe not more importantly, but equally as importantly, is that you have, or equally as important rather, is that you have a better ability to enforce some of these patents. So we've had the experience where you have foreign origin applications or foreign origin eventually that become patents here in the US, and you look at the claims and you look at what was done. Some of them go to grant very quickly or with minimal prosecution, and you have essentially the claims that are according to the old school approach, I guess, if you want to reference it that way, you have a minimal number of claims, so less than 10 typically, and you have wording that maybe was intended for a different jurisdiction. Those can be problematic. So the base invention is a good one. Maybe the specification is a good one. The claims, on the other hand, are not according to U.S. practice, or not as enforceable to U.S. practice as we would like. And that it happens occasionally. You look at something again with such a large docket, you're going to get great patents and things that just hit the ball out of the park, and you're going to get some that maybe are narrowed more than you would like. And I think we've all experienced that. The advantage of this type of approach is that you're anticipating that before you get to the point of allowance. So you're getting extra claims, you're getting maybe 20 claims or maybe 2 or 3 independent claims versus 1, and it gives you a lot more enforcement ability. So again, cost savings is great. Again, initially that's something that we're all concerned with budgets. If you're looking to use your portfolio, and if you're using to actually evaluate your portfolio and the value of the different patents, that's what we're going to get value from. You're going to get a lot more oomph with each claim.
Right. And the other thing to piggyback off that is, a few slides ago, we talked about, we showed an example of a claim amendment coupled with a new claim that was prepared upon entering the U.S. And like you're saying, Anton, why not just keep that one claim that you can and do kind of as little amendments to it as you need to, just to get it ready for examination. But now you're pairing it up with a brand new claim that's written that might be more focused on the invention. So now, just by default, you've got 2 completely different scopes of protections. One might be even include some language on there that you may not see as necessary to hit at the point of novelty and at the invention, but it's certainly, maybe since it is longer and has more claim limitations on it, let's say it could be a more difficult claim to challenge in an IPR or something.
Exactly.
And then couple that with a new claim that you have that's much more targeted on the point of novelty. You can kind of get in and out with that claim on an efficient level. You're kind of attacking your patent scope from 2 different angles.
Right. And I don't think that extra effort, frankly, from my own experience from drafting some of these extra claims, most of the work of these applications is done. The spec is drafted, the figures are there. It's basically you're interpreting them and adding some claims, which if you have some experience level, it's not a lot of added work. It is some added work, absolutely, but it's absolutely worth it. So we can all talk to this at some point or another, but I think, again, there's as many opinions, and this is an eternal debate with in-house counsel on how exactly and what percentage of work is done in-house versus outside. And I've heard everything from we send all work outside and we just manage to the standard I mentioned earlier. We know the business and we know what good claims are and what we need to do, and we just send everything out, to the other extreme, which is we know these applications best, we know this product the best, and we're going to draft them all and prosecute them all in-house. My preference is do something in between, and some of the reasons are listed here. You get a balance between cost and experience and efficiencies. So my theory, at least, again, the opinions on this vary as wide as any patent attorney or in-house counsel, and I've heard all of them, and they all have decent points that go across the board. But having some in-house expertise and knowing, again, all the things that we just brought up regarding claiming, regarding the latest case law in the U.S., regarding your product portfolio, regarding your strategies, having that base knowledge and having the ability to prosecute the patent and to draft your own claims gives you a greater authority and expertise in dealing with outside counsel. So having that split, whatever it may be, could vary between 20% to 80%, depending on the availability of in-house resources. At least having some base knowledge of where you want to go and how you want to do it. I think any of you that have drafted claims or applications, if you don't do it for a period of months even, you lose that ability very quickly. Not that you lose it, but you get rusty, I would say. Having that consistent practice, I think it, again, drives down costs to some extent. It keeps your I'm sitting here with outside counsel, but it keeps your outside counsel honest to a large extent, because you know the claims that you like and you know the claims that are working for you, especially, for example, on the enforcement side. And I think when you have that knowledge and ability to interact with outside counsel, it benefits you, the trust factor with outside counsel and with in-house inventors, and business people. And I'll reiterate, different companies have different approaches. So that's not the right one, but that's my approach, at least in our department. And I've heard everything between. I know larger departments that have a completely different mindset. I don't know if you guys have experienced both, either sides of the coin.
Yeah, with our clients, I think it's all over the board.
It
and
is.
It's really, like you said, company philosophy and what works best with them, given the company's resources and how IP management views how they want to use their in-house counsel and so forth. So.
Yeah, the one point that I did mention actually on a previous slide on amending these claims, the new style approach on not adding new matter. And I think that's a common battle with this, doing a preliminary amendment, for example, that you're not adding new matter and there isn't that ability to go back to the original priority application or to the translation. And you guys have any thoughts on that, on how well that works and where's that line crossed or where's that fine line?
So treated are similar to making amendments to the specification in a U.S. originating case. So you can make amendments to the specification that don't add new matter. So synonyms or something that's similar or said another way is okay. So one of the things that Mike mentioned was, in U.S. practice, we don't like to see the word invention. There's a lot of different words that you can use instead of invention that are, the same meaning that may not, for the foreign counsel, what they intended to say, but may not be applied the same way under U.S. law. For example, you can say embodiment or disclosure, because that's really what the foreign counsel is saying. They're not trying to limit their specification to a single type of embodiment or single invention. And so that being said, of course you have to keep that in mind and be careful not to play with fire, it'll get burned. So you want to be intellectually honest and keep things the same. I wouldn't advise going outside of that scope unless you want to lose your priority or ability to enforce that patent.
All right.
So we've got one question here. Actually, this is probably more for you, Anton. It says, for work done by outside counsel, do you prefer dealing with a central or single law firm that coordinates foreign prosecution, or deal directly with law firms in each foreign country?
Well, we have the advantage of having foreign offices or foreign IP departments. Again, when I say foreign, I mean non-US from our perspective, that can coordinate a lot, and they have the domestic law firms that they're comfortable with and they use, and they coordinate that prosecution. So in our main markets, for example, Germany, China, Asia Pacific, we have IP departments. So we can send work there and they can decide which is the best outside counsel to use if they want to use outside counsel, and they manage their dockets and whether they're going to file it in-house or outside. Approaches in the past, and I still think ours is the best if you have the resources to handle it, that you go directly to the foreign counsel. There's different services in place now as well, where you can have either you could go to a central service, and I'm not going to name any, I'm not going to make an advertisement for other companies or something, but you can go to a service and they have a roster of law firms that they vetted that they can use, and then you can trust them with that. There's another up and coming services where you can go to a central service for filing in foreign countries, and then you direct that service to transfer it to your substantive law firm. So it's a bit of a mishmash or combination of the two, where you have a central filing service, so you don't have to send all these order letters, but you have vetted or approved substantive or prosecution firms that you deal with in those particular countries. So again, it's as many answers as there are probably companies, but our approach is to deal directly with them. And then if you have a smaller law firm, maybe a central service or central point of contact, someone you trust and know those law firms and has dealt with them for a long time, would make more sense.
We've got looks like one last question here too. Are there any recommendations or comments regarding filing PCTs claiming priority to U.S. provisional cases and entering the U.S. and all other patent offices at the same time off of the PCT?
Yeah, we've done that in the past.
Provisional to PCT and then back to U.S. and everywhere else.
Yeah, we've done that. I don't know that we went away from that practice. I think it created undue complication on the U.S. side. Again, it comes back to the filing strategy to Larson, and I can only add 2 points to it. But we did that for a period of time where we filed sort of the PCT as a non-provisional and filed national back in the U.S. And it might only make sense if you have 5 countries or 6 countries where you're doing it in. But we've gone away from it because it's expensive. And if you aren't certain you're going to be filing in those other countries, you get yourself that you have a year anyway to decide. So I don't know if you had some comments to that.
Yeah, the only thing I would add to that is you better make sure that the provisional application you're first filing is a very good provisional application, because
that's the other side of it.
You have no idea what the other country's laws are regarding the benefit of priority, et cetera. So, if you already are making your provisional application that good that it can be based on for all the other foreign filing applications, maybe you just make that your non-provisional filing.
Exactly. And that's what we went to essentially. We went away from using provisionals in any sort of other way other than what they're intended for, which is basically emergency, short-term, quick filing. If you're going through the effort of preparing such a good application that you could basically file as a PCT, you might as well just file as not provisional.
I was saying it's a spin-off of a Forrest Gump quote. Provisionals are like a box of chocolates. You'll never know what you're going to get. Because some of them are great and some of them, you really can't work with them.
Yeah, so I think this is again, it's similar to the question that was just asked, which is, how do you manage outside counsel and counsel in foreign countries? Again, we have I wouldn't call it the luxury, but the strategy of having local offices in each country. And that's because we have the ability to do that because of the size of the company and the size of those markets. That's not always the case. And again, with smaller countries, or in our example, Brazil, we manage Brazil essentially. So from the US. So you can have, but we're not Brazilian patent attorneys. So we handle those countries differently. We file, for example, in Brazil directly. Again, if you want to use U.S. counsel, outside counsel as a managing counsel, I'm sitting here with outside counsel, but my advice would be not to go that route if you can avoid it. I think they have their strengths, and it's not necessarily. It's knowing U.S. law. It's preparing your applications in a proper way for enforcement. It's enforcing those applications. It's not necessarily and again, you guys can correct me if I'm wrong, but it's not necessarily in managing outside counsel unless you're forced to do it. I don't think it's the most efficient way to do it. And again, there are now services available where you can say these are vetted services, or you file and transfer to this service that might be better suited to that. Again, depends on what your resources are.
Yeah, sure. I think exactly what you said. I think it depends on the resources that you have. Schaeffler is a massive company with massive IP department, and they have the resources to manage both, work in-house and outside counsel all over the world with their global offices. And what we see with some of our clients is managing, they rely on us with U.S. offices and knowing their product line and knowing their goals and strategies. They use their trust in us as the main office to work with our foreign counsel that we have relationships with and that we have trust in to kind of help guide them through those other processes, because the company may not have maybe one patent attorney in the U.S., but nowhere else in the world, and then they have to have some expertise and trust, and it's tough to trust counsel 3,000 miles away if they have no.
Yeah, I think an important factor in that is how many applications are you filing. If it's just 10 applications that you're looking at filing in foreign jurisdictions, then it makes sense, maybe because you don't have those relationships, you don't have those law firms set up where Brooks Cushman may. If you're doing 200, maybe you should look at other resources. It's maybe not the best approach. So it just depends, and again, what you're able to do.
So I think that wraps up where we are. We're out of questions as well and out of slides. Perfect timing. So we want to thank you guys all for listening to our webinar today. And if you have any questions relating to today's materials, our contact information is on the front slide, or feel free to contact us at any time. Thanks very much, and we look forward to hosting another webinar for you.